alter pre-existing employment law rights and obligations. Another important point to note, just before we move on, furloughed workers can be rotated on and off furlough, provided that each period lasts for a minimum of 3 weeks. So moving on to the next slide, which employers can use the scheme? The scheme is incredibly broad. All UK entities are eligible to use the scheme. This includes businesses, charities, agencies. This is provided that 3 conditions are met, and this is set out as point number 2 on the slide. So they need to have a UK bank account, they need to have created and started a PAYE payroll scheme and notified this to HMRC through a real-time information submission, either on or before the 19th of March 2020. So a real-time information submission, for those who aren't familiar with this, basically notifies the government every time an employee is paid, and it's a live transmission of that payment to the government. In addition, the employer should have enrolled for PAYE online, and that process can take up to 10 days. The guidance provides that whilst employers who receive public funding for staff costs would be able to access the scheme technically, if this public funding continues, they are, however, expected to try to use it to pay staff as normal, as opposed to relying on furlough. So now, whilst the purpose and spirit of the scheme is to prevent redundancies, actually there are much broader and looser criteria for eligibility. So if we could have the next slide, please. This sets out that position. So paragraph 5 of the Treasury Direction clarified that a redundancy situation is not a precondition to access the scheme. This is clear from the fact that it states the instruction is given by reason of circumstances arising as a result of coronavirus or coronavirus disease. So the fact that it's been framed in terms of reason of circumstances, and those circumstances are not further defined, indicates that the government really did intend for as broad a range of people to be able to access the scheme without necessarily having to meet the legal criteria to satisfy that it would be a redundancy situation. And this has also been made clear by the guidance itself from the very first version. So when the guidance was first published on the 20th of March, it stated that whilst the purpose of the scheme was to help employers whose operations have been severely affected by coronavirus, however, it did recognise that different businesses will face different impacts from coronavirus. The latest version of the guidance has added that employers can furlough employees if they cannot maintain their current workforce because operations have been severely affected by coronavirus. However, no further definition has been provided of what is meant by cannot maintain current workforce. But again, it's clear that this falls short of the legal definition of a redundancy situation. The guidance also does not provide details of the evidentiary standard which will be required in order to claim. It's likely, and HMRC have been, trying to pay the amounts requested after basic checks. They have made clear, though, that they reserve the right to retrospectively audit claims, and it's at this point that wrongful and fraudulent claims are likely to be recovered. And it's also worth noting that they have made it very, very clear that they would be willing to prosecute any fraudulent claims in bad faith. Another point to note is that individuals can also furlough employees, such as their nannies or cleaners. However, those staff members need to have been paid through PAYE as of the 19th of March 2020. So if we could move on to the next slide, please. So what is recoverable under the scheme and what can actually be included? Now, the scheme in a nutshell is very simple. It allows UK employers to recover 80% of the gross monthly wages of employees. That is capped at £2,500 per month per employee. On top of this, employers can claim national insurance contributions and also statutory minimum pension contributions that are payable on that rate. The government has recently published an online calculator, which is very, very helpful. So if anyone needs to calculate that amount, it's worth using the online calculator. They've also published guidance, which contains worked examples that people can go through. The Treasury direction and latest version of the guidance also clarifies that when calculating wages, any regular payments are recoverable. And so this will include non-discretionary payments in effect. So this covers non-discretionary overtime, non-discretionary fees, non-discretionary commission payments. However, it doesn't include any discretionary payments. So for example, discretionary bonuses, tips, discretionary commission payments. And the guidance also clarifies that it does not include any benefits in kind. So for example, the value of a company car, so that won't be recoverable. Employers can choose to top up the remaining 20% of a furloughed employee's pay to bring it back up to the 100%. However, this is not required under the scheme. It's really worth being wary though, because if employers don't top that amount up, that could constitute a breach of contract. Therefore, it's really important that advance agreement is obtained to any variation of the terms of the contract to avoid being in breach of contract. The employer's national insurance contributions and automatic pension contributions are not recoverable in relation to any topped up wages. So moving on to the next slide, a little bit more detail about calculating pay very briefly. So for those employees who are salaried, the 80% is calculated by reference to the gross monthly salary as of the 19th of March 2020. For employees whose pay varies, the calculation depends on the duration of their employment in effect. So if the employee has been employed for 12 months or more, the employer can claim for the highest of either the same month's earnings in the previous year or the average monthly earnings from the 2019 to 2020 tax year. If the employee is employed for less than 12 months, the employer should claim for 80% of their average monthly earnings from the point at which they started work. So moving on, so who can be furloughed? Again, this has been a bit of a minefield with loopholes and then subsequent filling of the loopholes by guidance and a very, very piecemeal approach. However, from the outset, what has been clear is that a very wide range of individuals can be furloughed. So I've been referring to everyone as employees for ease, and the Treasury direction also refers to the entire group as employees. However, employee is defined much more broadly than the definition set out in the Employment Rights Act. An employee for the purposes of the Coronavirus Job Retention Scheme is defined by reference to UK tax law. And I've set out the guidance there, which makes it very clear that as well as employees under the Employment Rights Act, that in addition, the definition will cover LIMBY workers and directors as well. One thing to note here is that the requirement that these workers have to be paid through PAYE will in reality end up excluding many gig economy workers, even though they technically do come within the ambit of the scheme. So in relation to directors who are salaried and paid via PAYE can be furloughed. In most cases, the decision is one which will be made by the company board. There was a lot of uncertainty about the work that a director can carry out whilst on furlough. This has been clarified now by the direction, the Treasury direction, which states that directors can do only that work which is necessary to comply with their statutory minimum obligations. So that will be filing annual returns, and they can't do any more work than that in effect. So in relation to foreign nationals, the guidance for employers actually confirms that since the money for the scheme is not public funds, foreign nationals can be furloughed, and the scheme is accessible irrespective of the staff members' visa status. So in relation to employees who have stopped working, employees who are on the employer's payroll on or before the 28th February and who stopped working can be re-employed and then furloughed. Now, this is the case even if they were not re-employed by their employer until after the 19th of March. And one thing that's really important here is that the reason that that employee stopped working is immaterial. So they could have been dismissed, they could have resigned for whatever reason, or it could have been a redundancy situation, but they can still be re-employed and furloughed. And this also makes it clear that a redundancy situation is not a prerequisite for access, because given that these individuals can be furloughed even if they've left for any reason at all, suggests that the scheme is intended to be very broad. However, a question that's arisen as a result of this has been whether employees have a right to be re-employed. They don't. This is a decision for the employer. And again, this is a situation where the reality might diverge from what is technically possible under the scheme, because employers might in practice be unwilling to re-engage workers because of the administrative burdens and complexities of doing that. So very quickly, in relation to fixed term contracts, those workers on fixed term contracts can also be furloughed. If the contract has not already expired, then it can be extended or renewed, and the worker can then be furloughed, so long as a RTI payment was notified to HMRC on or before the 19th of March 2020. Workers on fixed term contracts which expired after the 19th of March can also be furloughed as well. Now, moving on to the process, thank you, the process that an employer has to follow to furlough an employee. The furlough scheme remains subject to normal contractual rules as well as statutory employment rights. It doesn't allow an employer to reduce wages to 80% in the absence of agreement. Therefore, unless there is an unambiguous unilateral variation clause which very clearly extends to pay and covers the situation, the employer will need to be able to obtain agreement of the employee before placing them on furlough. For most employees, however, furlough will be the best option that's available to them, and so they're likely to accept this. So this is another area where there's been some inconsistency between the direction and the guidance. The direction requires advance written agreement between the parties before an individual can be placed on furlough. On the other hand, the latest version of the guidance only requires that the employer must confirm in writing to their employee that they have been furloughed once this is done. Given the conflict and uncertainty, it's probably best to attempt to meet the higher threshold that's set out in the direction. So collective agreements, very quickly, if a collective agreement is incorporated into an individual's contract, then changes to that collective agreement which extend to pay will result in changes to an individual's employment contract, which means that they can be placed on furlough through that route as well. And I have detailed notes on this, which I can send after the presentation. So moving on to the work that's permissible on furlough, employees are not permitted to work for the employer who furloughs them during this period, and that is very, very clear. The guidance that was published on the 4th of April has clarified that where an employee has 2 jobs, each of the jobs is to be treated separately for the purposes of the scheme. This means that an employee can be furloughed from either one or both of these jobs, and the result is that the cap of £2,500 applies separately to each of the jobs. The 4th April guidance also did make clear that an employee who has been furloughed can get a job with a different employer whilst on furlough. However, that's only possible where the 2 conditions which are set out at point 3 of the slide are met. So essentially that employee is able to return and that everything's agreed well in advance. And the purpose of this seems to be to try and allow individuals to plug shortages in workforce during the coronavirus national effort. So moving on to the next slide, which is the last of my substantive slides. Training and furlough, this is another area where there has been inconsistency between the direction and the guidance. The direction appears to impose additional requirements to those contained in the guidance. The guidance only requires training to be of a kind which does not generate revenue for or provide service to the employer or an associated organization. However, the direction also requires that training is directly relevant to the employee's employment and is also agreed in advance. To me, the logic of this doesn't seem particularly clear, and it doesn't seem that it's really necessary to try and prevent misuse of the scheme. I think that this is probably something that's not really been thought through very thoroughly. So now moving on to some of the other issues which arise when the scheme intersects with other aspects of employment law. So national minimum wage. If an employee is on national minimum wage and paying them 80% of their regular wage would put them below national minimum wage, then the employer is not in breach of national minimum wage legislation. This is because the minimum wage legislation is not applicable to employees who are furloughed and so not working. If, however, an employee is in training whilst on furlough, then they will be entitled to be paid at least national minimum wage. So the employer will have to top up that amount to make sure that they receive at least national minimum wage. So 2P and furlough, again, this is an area where commentators expressed the fact that there was little guidance on this and there's a big loophole, and subsequently this has been filled in. In short, now the position is that that an employee who 2P transfers over to a new employer on or after the 19th of March can use the scheme and can be furloughed. So the scheme does cover those who transfer over, provided that the normal 2P rules are all complied with. So holiday pay and annual leave on furlough. This is something that's only very recently been clarified. workers do continue to accrue holiday pay whilst on furlough, and so they can take holiday whilst on furlough, and this does not break the 3-week period. And in terms of pay, whilst they're taking this leave, the employer will be obligated to top up for any statutory holiday pay to what their normal pay would be if they'd taken holiday. Another thing worth noting here is the guidance does state that employers can restrict individuals taking holiday whilst on furlough, provided that there is a business need for this. And something which is a little bit ominous is that the guidance does state that the government is keeping its policy in relation to holiday and furlough under review, and therefore this is something on which more guidance is probably going to be on which there's probably going to be more guidance very, very imminently. And just quickly, some comments on notice pay on furlough. So the question here really is, what notice pay should the employer give to employees who are on furlough? Will it be the 80% or will it be the amount to which they're normally entitled? So in reality, my view is that a tribunal is going to attempt to ensure that employees receive the ordinary notice pay to which they would have been entitled and not the reduced amount. This is because it does seem a bit unfair that an employee who agrees to help out their employer by agreeing to be furloughed is then prejudiced in this manner. And there are a number of ways that a tribunal could attempt to do this. They could say that the scheme just does not apply to notice, or they could find that when the parties agreed to contractually vary their terms, that there was an implied term which excluded notice for those purposes. So yeah, that is a very whistle-stop tour of the scheme and some other issues which arise from it. I do have detailed notes on this, which I'm very happy to send out afterwards. And now I'll hand over to Margherita to carry on with the presentation.
Good afternoon, all. Thank you for attending, and I do hope I will be able to meet you soon in person. I will look at redundancy, starting briefly with the definition of redundancy and how it works, and then moving on to when a redundancy will be held to be unfair, which is most relevant to the current circumstances. So first, redundancy is defined in Section 139 of the Employment Rights Act. There are 3 broad circumstances which amount to redundancy situations. The first is a closure of business, the second, a closure of workplace, and finally, where there's a diminished need for an employee to carry out work of a particular kind. A couple of important points about this. In terms of the third example, the focus is on whether there is a diminished need for a specific employee to do work of a particular kind. What's important in this regard is that an employer will not be required to show an economic justification or a business case. So there isn't a strict question about the motivations behind making a redundancy. In terms of reduced work hours that might be interesting in the circumstances of coronavirus, there's a question about whether reducing work hours can create a redundancy situation. There's inconsistent decisions by the EAT, but ultimately in Pacman, it was held that reducing work hours can create a redundancy situation. So employers should keep an eye out on this. Moving then to qualifications and exclusions. Generally, redundancy payments are available to employees only who have been employed for 2 years continued, and the relevant statutory provisions are on the slides. There is one exception, which is layoff and short-time work. So where employees are laid off or put on short-time work, they will be entitled to statutory redundancy pay so long as they follow the statutory procedure minutely. Alternative job offers, these are particularly important. Why make one? for two main reasons. First of all, if the employee does accept the offer, the employer will not be liable to pay redundancy payment. Second, there is a risk that a dismissal will be found to be unfair where an alternative job offer isn't made. And finally, if an alternative job offer is made, is held to have been suitable, and the employee unreasonably refuses the offer, then again, the employer will not be liable to statutory redundancy pay. Moving on to the fairness of redundancy procedures. Generally, a redundancy is a potentially fair reason for a dismissal. So in most or many cases, an employer is discharged of liability by paying redundancy pay. However, it is open to the employee to argue that the dismissal is in any event unfair. First, the employee may argue that dismissal was not truly by reason of redundancy, but was because of a potentially unfair reason. Alternatively, the employee can argue that the dismissal was by reason of an automatically unfair reason, or because it was in any event unreasonable. Where the employee argues that dismissal was not by reason of redundancy, then the presumption that exists under section 163 subsection 2 of the Act, and which applies when an employee is claiming statutory redundancy pay, is disapplied. And in terms of reason, all that must be shown by the employer is that a redundancy situation existed. The employment tribunal will not inquire behind the reasons for redundancy. These are irrelevant. Automatically unfair reasons are found in section 105 of the Act and are virtually identical to those that apply in unfair dismissal situations. What is most interesting are the potentially unfair reason. A couple of key examples are that the employer unfairly pooled and selected employees for redundancy, that it was unreasonable to dismiss where suitable alternative work was available, or that the redundancy procedure was defective. The test was set out in Williams and Compare Maxim, and generally the employment tribunal will look at whether the selection criteria were objectively chosen and fairly applied, whether an employee was warned and consulted, whether where relevant a union's views were sought, and whether alternative work was available. However, these are only guidelines and the assessment is always one of fact for the tribunal. Moving on to the first subsection in terms of procedural fairness. So pool for selection. It is for the employer to identify the group or pool from which those who are to be made redundant will be drawn. The employment tribunal will inevitably look at this question first, because applying selection criteria to a wrong group of employees may be found to lead to an unfair dismissal. In Tamek and Ryan, the Employment Appeal Tribunal held that an employer's failure to consider the pool question at all will make a dismissal unfair, unless, as was the case in Zeff and Lewis Day, the circumstances are such as a complete business closure, where it will be useless to consider the question of pool at all. However, these are circumstances at the fringes of redundancies. Otherwise, unless there is a customary arrangement or an agreed procedure, the employer will have wide latitude in identifying the appropriate pool. And it need only show that it applied its mind to the problem and acted for genuine motives. The question for the employment tribunal is whether the employer's choice fell within the range of reasonable responses. So it is not to substitute its own view to the employer's. However, in any event, the employer must act reasonably, and the employment tribunal will scrutinize a number of matters. For instance, it will consider whether other groups of employees are doing the same or similar work. If that is the case, the employer will need to have good reasons for excluding a particular group of employees from the pool. This was the case in the British Steel case, which is referenced in the next slide. In this case, multi-skilled craftsmen were held to, it was held that multi-skilled craftsmen should have been included in a pool of mechanical and electrical engineers because the work was held to be the same or similar. The second circumstance that the employment tribunal might consider is whether the employer was expected to include in the pool employees doing interchangeable work. So in Blundell Permaglaze, for instance, it was held that drivers and warehousemen had to be included in the pool because drivers could and did in fact in the past perform the work of warehousemen. Compare that to Lomond Motors, where the opposite conclusion was reached, where accountants were not included in the pool because they had different levels of experience. So the fact that these two jobs required different levels of experience meant that they were not properly interchangeable, and the employer was entitled not to include one of the workers in the pool. Another interesting question is whether the employer might want to consider bumping. So bumping is illustrated by the diagram on the screen. And essentially it refers to a situation where you have one business section where there's a diminished need for an employee and a second section where the need is the same. Bumping refers to transferring an employee from the first section into the second section and bumping or dismissing an employee from the second section. In Lionel Leventhal, the dismissal for redundancy of a senior editor was held to be unfair due to the employer's failure to consider bumping a more junior editor instead. So again, the employer might have to take into consideration whether it's possible for it to bump someone with less experience, for instance. Finally, in terms of pool, can there ever be a pool of one? That sounds counterintuitive, and indeed in Capita Hartshead, it was held that there couldn't be a pool of one because the procedure was held to be incredibly procedurally flawed. However, take the situation in Halpin and Sandpiper, where there was a closure of an overseas offer with a single employee. In a case such as that, it would make sense to have a pool of one. In Wrexham, the court held that ultimately the pool is not required directly by statute. So there will be occasions where it's reasonable to have no pool at all or a pool of one. Moving on then to selection criteria. Once the employer has identified the relevant pool for selecting an employee, it will need to apply selection criteria to determine which employee to make redundant. There are a number of assessments that the employment tribunal is entitled to make about selection criteria. And there are a number of pointers that employers should keep in mind. First of all, the criteria should be clear and transparent. So for instance, it might be unfair to score an employee on a range of pre-advised criteria and then to take into account additional factors. And that's indeed what happened in Watkins and Crouch. Second, the criteria should be objective. What this means is that they must be verifiable by reference to data such as records of attendance, efficiency, length of service, so on and so forth. Examples of criteria that were held not to be appropriate in the case law include a criterion that the employee would keep the company viable. This was held to be entirely subjective. Cost savings was held to be not an inappropriate yardstick by which to assess performance. And commitment, which was held not to be measurable. On the other hand, criteria that were deemed appropriate were attitude or even adherence to company values. And the court indeed, and the tribunal in Mitchells of Lancaster and Tattersall held that the fact that the criterion in question might require a degree of judgment by the employer doesn't necessarily mean it cannot be assessed objectively. Provided that the criteria are objective, the employment tribunal should not subject them to over-minute scrutiny. So in British Airspace and Green, it was held that the task for the employment tribunal is to satisfy itself that the method of selection is not inherently unfair and that it is applied in the particular case in a reasonable fashion. The important point is ultimately that the employer will have a wide degree of discretion in selecting and applying the criteria, and that the employment tribunal is only entitled to interfere in cases falling at the extreme edges of reasonableness. Examples of more common criteria in the case law include last in, first out. However, employers must be careful not to discriminate by reason of sex when applying that. Performance, skill, and knowledge. However, a stumbling block is how this is measured. If it is monitored, the employer will be required to produce documentation. If not, there is a risk that the dismissal will be held to have been unfair. Flexibility of the employee, disciplinary records, attendance records. However, again, here there's a risk that if the employer knows the reason for absence and doesn't take that into account, the dismissal will be held to have been unfair. And finally, health. Although again, there's a risk of a finding of disability discrimination. So again, something that the employer must be careful about. Moving next to the manner of selection. The application of the criteria must be fair. And applying the criteria in a certain way may make the dismissal unfair even before considering whether consultation happened. So examples from the case law: in Lovell, the employee had not been made aware of concerns about his performance. In Alexanders and Maxwell, the selector had been given no guidance. In Bolton and Arnold, there had been a departure from an agreed procedure. In all these cases, the manner in which the criteria were applied was held to have been unfair. Again, the employment tribunal's role is not to assess the actual scoring, nor is it to assess an employer's assessment of an employee. In Buchanan and Tilken, it was held that it would be unrealistic to expect an employer to set up the accuracy of information used by an employer by direct evidence. And this was confirmed in Eaton and King. There, a set of managers was unable to give a clear explanation of the selection process. However, it was held that that didn't matter. There was no reason why they couldn't have simply relied on the information supplied to them by the employee's supervisors. And the tribunal there held that unless an inference could be drawn from the information before the tribunal or from the markings that the employer used, that there was something unfair about the application of the criteria, then it was not for the employment tribunal to assess the information more minutely. And this was confirmed by the Court of Appeal in British Airspace and Green. One important point to remember is that the employer does have a duty to disclose assessments to the employee. And that's John. Next slide, please. Thank you. Just briefly about collective consultation. The duty to consult appropriate representatives is provided for by the Trade Union and Labour Relations Act. And length of consultation should be 30 days if there are 20 to 99 employees, or 45 days if there are 100 or more employees. In the British Coal Corporation ex parte Price case, the court gave guidance as to when consultation will be fair. In short, proposals should still be at a formative stage when consultation is undertaken. Adequate information and time to respond must be provided to an employee, and the employer must conscientiously consider the responses received. Moving then to individual consultation. In the famous Polkey case, the House of Lords found that an employer does not normally act reasonably if it fails to consult. Only if the employer could reasonably have concluded at the time of the dismissal that consultation was utterly futile and the decision to dismiss would be unaffected by any consultation with an employee could a dismissal in breach of procedural fairness be reasonable. Best practice drawn from the case law for the subject matter of consultation suggests that an employee should be given an indication or a warning that he or she has been selected for redundancy, that the employer should confirm the basis for selection, and that it should give the employee an opportunity to address any other matters she might wish to raise. In the Rowell and Hubbard group case, the court adopted the guidance given in British Coal ex parte Price, So that guidance applies equally in cases of individual consultation as in collective consultation. Finally, a few pointers from the case law. In Pinewood, it was held that an employee must be provided adequate information on which to argue her case. In Hilton, it was held that consultation is unfair if the employee is kept into the dark until the last minute. And however, in Lloyd and Taylor, it was held that a failure to consult or a failure to consult fairly can be cured at an appeal hearing following dismissal. Moving on then to the last point I wish to cover, alternative employment. As mentioned, it's in the employer's interest to offer alternative employment, and the employer should do what it can so far as reasonable to seek alternative work for the employees selected for redundancy. This is not, however, an obligation by law to look for opportunities, and that was made clear in Thomas and Beth's Manufacturing and Harding. A degree of objectivity in the offer of alternative employment is important. In Rolfe Martindale and Harris, 2 managers at risk of redundancy were offered a single alternative post. The employer's selection there for the alternative post, for the alternative job offering, was based on subjective criteria, including which manager had a less insular management style. The procedure was therefore held to have been defective and the dismissal unfair. However, in Morgan and Welsh Rugby, it was made clear that selection for an alternative job, unlike selection for redundancy, is forward-looking and focused on an ability for the employee to fulfill a new role. So although the tribunal can consider how far the selection was objective, the employer's assessment of which candidate will best perform the new role is likely to involve a subjective element of judgment. Finally, including unfair terms in a new offer of employment and dietary redundancy, but that is a topic on its own, and employers should definitely always consider questions of discrimination when selecting employees for redundancy. And I'll pass over to my colleague Beth, which will speak about unfair dismissals in the context of COVID.
Thank you, Margherita. After Boris Johnson's speech yesterday evening, this seems to be the topic of the moment on Twitter and in the media. And there are 2 likely ways in which unfair dismissals are going to arise. The first is the classic scenario when individuals refuse to work at all. And the second is when individuals impose limitations on when, where, and how they're going to work. I imagine as well there are going to be issues of unfair dismissal arising in the context of whistleblowing and COVID, particularly around, for example, PPE. We'll come to that later. The key protections are provided in sections 101, 105 and 44 of the Employment Rights Act. The section 101 provides for automatic unfair dismissal in circumstances of danger which the employee reasonably believes to be serious and imminent. A redundancy for a reason under section 101 is an automatically unfair redundancy under section 105. Section 44 has mirror provisions to section 100 with respect of an employee's right not to suffer a detriment. And we might address this at the end of my speech if we have the time, but I suspect that a number of employees will use section 44 to argue that they not only do not have to attend at their premises of work for the foreseeable future, but should also be entitled to their pay for that period. Moving on to the next slide. These are the key provisions which we can see at section 101D to E. Section 101D provides for automatic unfair dismissal in circumstances of danger which the employee reasonably believed to be serious and imminent, which he could not reasonably have been expected to avert, and left or refused to term. Section 101E is more wide-ranging. It refers to taking appropriate steps and to protecting himself or other persons. I think those words "or other persons" might be key in a lot of COVID cases, and we will return to those. Importantly, it is only Section 101E that has the further proportionality test at Section 100 subsection 2, which is in relation to the steps taken only. Moving on, as I addressed a few moments ago, I expect that Section 101E is where the real battlegrounds in unfair dismissal cases under COVID are likely to be fought. This is because I expect that a lot of individuals are not going to blanket refuse to attend their place of work and therefore refuse to work, but are going to refuse to attend at certain locations where their safety cannot be guaranteed to the same extent, only if and to the extent that PPE of certain types is provided, or perhaps at certain times of the day, if they can take public transport when it is less crowded, if they can drive into work, or at times when they might feel more confident cycling, for example. I know a lot of people who wouldn't dream of cycling into central London during rush hour. I also expect that Section 101E might well be used for individuals who refuse to attend their place of work specifically because a member of their house is shielding. And if they're arguing that it is that which gives rise to the serious and imminent danger. Because as we saw, it is Section 101E that provides for provides for other persons. Section 101D to E both contain a two-stage test. Were there circumstances which the individual reasonably believed to be serious and imminent? And as we can see for Section 101E, that first stage is expanded somewhat. And secondly, were those circumstances and were the steps that the employee took or their refusal to attend the sole or principal reason for the fact that the employee was dismissed? With COVID cases, and we will return to this, I am expecting that both questions will be a real battleground. And in respect of the first question, and this will take us on to my next slide, I expect that there might well be arguments raised at the EAT and perhaps even at the Court of Appeal as to whether that first stage is in fact two stages in its own right, and whether there is any degree of objectivity required in assessing those circumstances of danger. In Adhuha, the case on the slide we were previously on, it appeared to be part of one entire test. However, in Hamilton, the tribunal suggested in an obiter manner that in fact there may be a first stage before we even reach the question of what it is reasonable for the employee to believe. Now, danger in any event is not that emanating purely from the workplace itself. It is emanating from all those relevant circumstances. And we see this in the case of Harvest Press and McCarthy. This concerned an employee subject to the abusive behaviour of a colleague. The respondent tried to argue that that was not a circumstance of danger from the workplace. And the Employment Tribunal and the Employment Appeal Tribunal rejected this because the council directive from which Section 101D to E are derived used danger without that limitation. However, I think it's important to beware of an obvious danger, or a danger which appears to be obvious as in fact giving rise to such circumstances. And this is really brought home in the EAT case of ABC News Intercontinental and Gisbert. The claimant was a news reporter. The respondent was a broadcaster who operated a voluntary war zones policy, and the claimant refused to attend. The claimant says war zones were very dangerous. One of the war zones which was active at that point was Iraq, and the Employment Tribunal held at first instance that Iraq in 2004 was a very dangerous location. That refusal was in fact part of the reason why the claimant, who was a freelancer, did not have their contract renewed. However, what the Employment Tribunal said, and what the Employment Appeal Tribunal upheld, was that the employee was, their workplace was in London, and there were no circumstances of danger in relation to that workplace in London. The Employment Appeal Tribunal separately said that the employee couldn't, for those reasons, reasonably believe that he was in circumstances of danger. However, for the purposes of the first stage of the test, I think this is the relevant point, that circumstances, although they are not confined in the Act or in the underlying EU directive, are not so wide-ranging that they exist simply because there is something within the general purview of what the employee might encounter that is dangerous. Those circumstances must pertain to where the employee is and what it is that they are required to do. And this is why I think that that test will likely see some more legal argument when COVID unfair dismissal cases start to come through. And indeed, there have been a number of cases at first instance and confirmed in the EAT where circumstances of danger have not been found. In Bush and AP Construction, it was found that passive smoking did not constitute circumstances of danger. I think it would be very difficult for a respondent to rely on that now, given the fact that smoking is outlawed in the workplace, precisely because passive smoking is dangerous. However, it does go to illustrate, I think, that this question of danger will not be automatically accepted. In Dodd and Blue Star Engineering, the tribunal also did not hold that dirty equipment could, in and of itself, create those circumstances of danger. Moving on then, the case law suggests that the tribunals will consider seriousness and imminence as separate issues, both essential to the question, and will scrutinise these in some detail. In Dent and Greater Reading Omnibus, the indicators on the bus failed and the driver refused to continue to ride the bus. And the tribunal held that at that point there was a reasonable belief. That belief was based in circumstances that those circumstances gave rise to a belief in seriousness because of the effect of a crash of the car, of the bus, but also imminent circumstances because there was very little the employee could do in those circumstances to avert it. If he continued to drive without indicators, there would be a very clear and immediate risk. Contrast that with ABC News Intercontinental, where there was no imminent danger because the claimant was not in a war zone at the relevant time. In Hoyle and Nottingham Ambulance, the shed rule was considered to be was argued as the relevant part of the stage 1 test because it encouraged ambulance drivers to breach the speed limit. However, the tribunal held that the employee could not have a reasonable belief that that was both serious and imminent, because although the danger of a crash would be serious, it was not imminent because the employee could take care and seek assistance in avoiding that danger. Moving on, the claimant's knowledge will be fundamental to their reasonable belief. In the case of Edwards and Secretary of State for Justice, a number of employees refused to take a vehicle provided by the Minister of Justice to transport them to a work site. In fact, that same vehicle had been used without incident for a previous group of employees. However, the employees on that vehicle had no knowledge of that fact, and therefore they had a reasonable belief as to the seriousness and imminence of danger in the use of that vehicle. It is not a question as to what the employer knows about their safety mechanisms, it is a question as to what the employee knows. And this might be particularly relevant, for example, if an employer knows that they are having certain aspects of their workplace disinfected on a regular basis, but do not tell the individuals who are expected to come in before they require them to come in. And this is a particular issue which we might see this week, given the confusion as to the current state of play expressed by many employees, many employers and many trades unions following Boris Johnson's speech yesterday. Lots of different workplaces are now going to be having to make decisions for themselves as to what they consider the risks to be and what their appropriate mitigations are. And it is vital that those are communicated to employees before those employees are expected to attend. Now, although we are talking about automatic unfair dismissal here, it is important to note that there is still a question as to the matrix, the connection between the employee's act or refusal to act and the decision to dismiss which the employer takes. And this is seen in the case of Chief Constable of West Yorkshire Police in Khan, and applied in the context of Section 101 in Balfour Kilpatrick, a case to which we will return. And this question as to the conscious or unconscious reason, again, might be very significant and have some very fine details in COVID-related cases. Because if, for example, an employee refuses to attend, the employer might say, in that case, I can no longer provide you with employment. You are not subject to redundancy pay because you have less than 2 years service. But if you will not attend to do this job, then I have to give you notice. Now, if the refusal to attend is the reason, then that would be an automatically unfair reason. However, it could be very difficult and very nuanced in circumstances where the reason is not the employee's refusal per se, but the consequences of that refusal on the state of the business and what happens with the business. And I expect that we will be seeing that with a lot of jobs in the next period of time, which can only be done from a particular location. It is important to note, and I will return to this towards the end, that the protection under Section 101 is an individual protection and not a protection to the workforce as a whole. And that again might be something which influences what the reason for the dismissal was in respect of each employee, because each employee will be taking a decision for themselves as to what their reasonable belief is and whether they should attend or not. And there may well be other employees who are willing to continue working in those circumstances. In the COVID context, I think there are going to be some very particular issues on the facts and the law which arise. The first is that this will be a very workplace specific issue. The situation in a hospital or a care home, for example, is going to be very different from the situation in most solicitors' offices. Indeed, those of you who work in your own office will be in a very different position from those of you who work in open plan offices, for example. I also think that there is a real question as to whether circumstances of danger can be automatically assumed to apply in the case of COVID. And this is because COVID is, for the most part, a mild illness. There are certain groups of people for whom it is not, but for most people it is a mild illness. For many people it is also a symptomless illness. But that danger is not automatically inherent in every workplace. That danger only exists if there are people in that building transmitting the COVID virus, or if the employee risks coming into contact with the COVID virus on their route into work. So we might be facing examples, for instance, of employees saying, well, hang on a second, you can drive into this place of work and you might well be the only person in your part of the building whilst you're there. Or we know that the people you have shared an office with all had COVID in February, March, April. Therefore, we don't consider that any circumstances of danger apply to you. Whereas the employee might say, well, hang on a second, I consider that I have a reasonable belief that I'm at a serious and imminent risk because I have been reading about how long it takes to transmit COVID between two individuals who pass at 1 meter between each other in a confined space. I believe that I'm at a serious and imminent risk for all of these reasons. And this is why I say that that question as to whether there is an underlying objective test could be a really serious issue in the employment tribunal. The other issue which might arise is that an employer might turn around and say to a workforce, hang on a second, you are all aged 18 to 30. We know that the risk for 18 to 30-year-olds is very low. None of you have declared any sort of underlying condition that would enhance your risk, and therefore, whilst we might make separate arrangements or agree to furlough older staff, for example, or staff with underlying conditions, we do not consider that those risks apply to you. There is an unresolved question, I think, as well, as to whether the stress and the fear of contracting COVID and contracting a serious form of COVID could in fact arise as a circumstance of danger in and of itself. In the Harvest Press case, which my previous slide referred to, we saw that abusive behaviour from a colleague could constitute danger. That danger was unconfined. That would suggest that a potential impact on mental health could be sufficient for circumstances of danger. However, in the case of Balesford and John Reed, the claimant's case was struck out, and Her Honour Judge Eadie said, hang on a second, what the claimant's case amounts to is absenting himself through stress from work. That is not the same as circumstances of danger. And therefore, I think there will be a real test in the Employment Tribunal and in the Employment Appeal Tribunal as to what the line between those is, and as to whether any individual can rely on their fear of the risk of contracting COVID There will also be a number of questions around proportionality and, for example, the point at which a failure to provide PPE or the specific types of PPE which the employee is seeking might in and of itself constitute, might have an effect on this. But I also think there is going to be a question for individuals who say, or individuals who are in the position where they do not reasonably believe themselves to be at a serious and imminent risk of COVID, but members of their family with whom they are shielding are. And this might apply either to those 18 to 30-year-olds whom I mentioned before, or other people who test positive on an antigen test when those become available. And they might say, for instance, hang on a second, my 75-year-old mother or my husband who is undergoing cancer treatment and has asthma hasn't tested positive on the antigen test. And if they get it, that could be catastrophic for them. In terms of how the tribunal will handle these sorts of issues, there are a few things I think it's important to remember. The first is that the tribunal will have regard in assessing whether those circumstances existed and the reasonableness of the employee's belief to wider health and safety legislation. And in particular, they will have regard to whether the risk assessment on whether the employer has conducted a risk assessment which is suitable and sufficient for the relevant purposes under section 99, section regulation 3 of the 1999 regulations. If the risk assessment is suitable and sufficient and has been communicated to employees, I think there is a real prospect that an employer might succeed at a tribunal. I think it would be a very, very bold employer, however, who relied on government guidance at the moment to say that its employees should come back to work. Government guidance is not a substitute for the requirement to undertake their own suitable and sufficient risk assessment. And this, I think, could become very interesting because, generally speaking, the Health and Safety Executive does not prosecute where an employer, or would drop a prosecution on health and safety grounds, where an employer can demonstrate that there is guidance, that there is full and effective guidance, and the employer has been following that guidance. Conversely, the Health and Safety Executive is likely to prosecute where there is guidance which the individual employer has not been following. In these circumstances, and I think given the garbled messages that came out or perhaps have been interpreted from the speech last night, I think the safest situation for any employer is not to rely on anything which government has said, but rather to do what they can in light of all the sources of information available, including information from Public Health England, from the members of the SAGE Advisory Group and others who have spoken publicly and issued and published information about risks arising with COVID. If an employer does not undertake its own health and safety risk assessment, and if they don't provide PPE or otherwise take steps to maintain a safe system of work, it's important to note that an employee might well consider, not only refuse to attend, but might well consider that there has been a fundamental breach of contract and that their dismissal and in fact that their contract has been repudiated, and they can argue that they have been constructively dismissed. And it's important to note that constructive dismissal can pertain to even circumstances where the employer's behaviour is perhaps quite reasonable or quite understandable. in the case of Bournemouth University and Buckland, the court held that even a failure to pay wages, where that failure wasn't out of malice on the employer's part, but because the employer itself was out of funds, would still count as a repudiatory breach. And in these circumstances, and in the case of COVID, I think, for example, an employer who doesn't provide hand sanitizer and disinfectant, not because they don't want to, but because the shops have run out, particularly if they fail to do so persistently, or doesn't provide PPE, would very likely be at risk of a constructive dismissal claim. We're going to turn now to that issue of members of the household, and that case of employees arguing that they can refuse to attend on the basis of shielding members. And in the case of Masiac and City Restaurants, it was held that the other person's element of Section 101E included members of the public. In that case, members of the public were members of the public actually in the vicinity of that restaurant and seeking to eat its food, which was relevant to the facts of the case. However, I think it is possible to argue by extension that other persons include other persons within the household. However, again, I think there might be some difficulty because Section 101E does not refer to a total refusal to attend work. It only refers to appropriate steps. And there might well be arguments run at the employment tribunal and at appellate level, which says, hang on a second, there is no reference in Section 101D to protecting other persons, and nor is there a reference in Section 101E to a refusal to attend work altogether. This is attempting to conflate two sections of the legislation, which Parliament has deliberately sought to keep distinct. And again, there, I think we will see some real arguments around that over the next few months. Lastly, developing this point slightly further, I think an employee who refuses to attend a workplace on the basis that they are living with people who are shielding might also be able to rely on Section 20 of the Equality Act 2010 and might be able to argue that Section 101E should be read in line with that. Associative discrimination can apply to indirect as well as direct discrimination. And I think most people who are shielding can probably rely on the definition of disability as falling within the Act. There might be some cases in which people can't, but I think overall, given the expansiveness of that definition, it would be difficult to see how a tribunal could say that a shielded person was not. Moving on then, I will end very briefly on some of the wider issues arising with unfair dismissal claims in COVID. As I said a while ago, the protection under Section 101 is an individual protection, it's not a collective protection. And therefore, there is no necessary right to take strike action, although there might be in other words, there is no right to walk out to compel the employer to put in place better safety provisions. Although there is some prospect that an employee could rely on Section 2372 of the 1992 Trade Union and Labour Relations Act, if relevant. If, for example, they said that there was some unofficial strike action that they were taking part in. However, where Section 101C, I think, will be particularly relevant is in cases which fall within what we might more broadly describe whistleblowing, but maybe slightly wider than that. So, for example, if an employee chooses to publicise on Twitter, chooses to draw to the attention of members of the public that who use that employer service, that the employer is taking part in practices which are harmful or potentially harmful to health and safety, then there is a strong prospect that they can rely on this. Section 101C has a broader use of language than sections 101D and E. So in these sorts of cases of whistleblowing or certain types of action, of similar action, there is no requirement to prove circumstances of danger. There's no requirement to prove reasonable belief in the seriousness or imminence of those circumstances. Rather, what the employee is required to do is believe that those circumstances are either harmful or potentially harmful to health and safety. And I consider that to be a lower test than under the later subsections. I also think that that wording might be significant because it would suggest that circumstances of danger has a threshold of seriousness to it, which is over and above something which is potentially harmful to health and safety. And it's on my reading of that I emphasise the point I made earlier, that in cases where there is a general risk of contracting COVID as a mild illness, not specifically pertaining to known risks in that particular workplace, I think it might be difficult for some employees to argue that they are entitled to refuse to attend altogether. Thank you.
Right, thank you, Beth. Well, we've come to the question and answer segment of the webinar, and I can see that there have been a number of questions that have been raised whilst we've been going through this presentation. So if you just bear with me, I'm just going to pick some of them at random. Preetika, one question that's been posed is, how often can an individual be furloughed?
So there are no limits on the amount of times that an individual can be furloughed, provided that each furlough period is for a minimum number of at least 3 weeks. This means that potentially an individual can be furloughed any number of times, and the individuals in a workplace can be rotated on and off furlough.
There was another question posed about furlough, and Preetika, what's being asked is, has any guidance been issued regarding those who are furloughed but have been asked to shield long term, or will there be any provision? Are you able to respond to that?
Yes, so this is another area, unfortunately, where there is confusion and inconsistency between different iterations of guidance. So the latest version of the guidance for employees states that if you're shielding in line with public health guidance or required to stay at home due to an individual in your house shielding, and you are unable to work from home, then you should speak to your employer about whether they plan to place you on furlough. So that part about you being unable to work from home is an addition, and previously the guidance didn't state that. Previously the guidance just stated that yes, if you're shielding, you're eligible, but now there's this additional requirement as well. So that is the position as it presently stands.
Fantastic. Margherita, a question for you. How do you think employment tribunals will view redundancy exercises where there is a furlough scheme in operation?
I was speaking while on mute. So that's one of the open questions. So there's a risk that where there is a furlough scheme available, as the one that is currently available for employers, choosing to make an employee redundant rather than placing him or her on furlough might be considered to be unreasonable, for the same reasons that it might be considered to be unreasonable for an employer to place an employee on redundancy where there is an alternative job available for that employee. Of course, it will depend largely on the factual circumstances that obtain, but it's an open question that is likely to come before employment tribunals, and employers should be ready to demonstrate good reasons for choosing to put an employee choosing to make an employee redundant rather than putting them on furlough.
Wow, there's been a lot of questions on these topics. Another question that's being posed is, and again, I think this is for you, Margherita, is do you think that the special circumstances defense could apply to collective consultation in light of the global pandemic?
Well, so although it is almost without doubt that an employment tribunal will accept that special circumstances exist, there is a global pandemic. I'm not sure if there's anything that fits the definition better than that. Even though the defense is available, an employer will always be required to take reasonably practicable steps to comply with collective consultation requirements, even when it seeks to rely on that defense. So see, for instance, Shanahan Engineering and Unite, that's EAT 0411-09. So it's clear from that case that it is always advisable for an employer to make some attempt at consultation as far as is reasonable, depending on what facts obtain in the circumstances. Another issue that I think might be relevant is, again, the availability of the furloughing provisions, because how could an employer demonstrate that it wasn't reasonable for it to place employees on furlough while consulting? Again, an open question on whether the availability of the furlough scheme will influence determinations in relation to reasonability or not of redundancy decisions. We shall see.
Beth, looks like there's a question for you. Would a redundancy during furlough still be automatically unfair if the claimant took action about health and safety, for instance, making a complaint?
It would not be automatically unfair, provided that the reason for the redundancy was not the fact of that complaint, but rather the objective, was rather, as objectively found, the fact of the requirements for redundancy found and discussed by Margherita in her slides. It is very clear from the construction of the legislation and also the case of the Chief Constable of West Yorkshire and Khan, as reflected in Balfour Kilpatrick, that there has to be more than a coincidence of factors. There has to be a connection between the two. The tribunal rejected the use of the term causation because it said that causation was a legal test, but what they were looking for was the reason as it existed in the employer's mind. If the reason why the employer dismisses somebody is because they have made a complaint, then that is likely to be unfair. If the reason why the employer has dismissed somebody who has made a complaint is because a genuine redundancy situation arises, then that is not likely to be unfair.
Thank you, Beth. And going back to you, Margherita, I think there's a query about whether a redundancy notice can be issued from the 1st of July during the furlough period if a business is suffering financial difficulty. I assume that's the instigation of consultation for redundancy that's being asked. Is that permissible?
I'm struggling to understand that question. So, well, if an employee is placed on furlough, it's still open for an employer to decide to make that employee redundant. If it does so, then the normal requirements for consultation would apply. irrespective of the furloughing decision. But I'm not sure whether that answers the question.
Yeah, just to add in relation to that, there's clearly no prohibition in entering into redundancy consultations. I think from the speaker's talk, the issue is really whether the existence of a furlough scheme and funding from the government renders or feeds into the Section 98.4 test that a tribunal will apply when determining whether a dismissal for that reason, where there's the provision of state funding, will render the dismissal unfair or not. Clearly, if the furlough scheme was due to end at the end of June, as was originally posited, although looking at the papers, there seems to be some suggestion that it will be extended into September, albeit at a sliding scale. A business is entitled to plan in advance, and you'll have seen from some of the correspondence and news about the airlines that indeed a number of airlines are considering doing that very thing. So I don't think there's any abolition of that. I think there's been clarification actually. Can we issue notice now but keep the staff on furlough and then make them redundant from 1st of July? Does that assist, Margherita?
Well, absolutely. I mean, if a redundancy situation exists and is established on the facts, then staff can be made redundant. The question is always, if there's an availability of this furlough scheme, are there good reasons for choosing to make employees redundant rather than keeping them on furlough? So rather than, if let's say we're considering whether to make an employee redundant or whether to put an employee on furlough now, if the choice is made to make an employee redundant, the tribunal might inquire into whether it was reasonable to do so given the availability. If an employee is placed on furlough now and the choice is made later on not to continue with furlough, then again, an employer might have to demonstrate why it was reasonable for it to choose to make an employee redundant rather than to allow the employee to stay on the furlough scheme if it is extended, of course. But there definitely has to be a good reason, and employers should expect to be asked to have evidence to show that keeping an employee on the furlough scheme was not a reasonable alternative to making that employee redundant.
Thank you. Beth, I think there's a question for you in relation to the query. Do you think an employer would have a better defense where they ask key workers to attend work in circumstances where the worker believes attending the workplace would put them in imminent danger?
A better defence in respect of key workers than in respect of non-key workers? No, I don't think that the status of an individual as a key worker will be necessarily relevant. The legislation doesn't make any distinction between key workers and non-key workers, and nor does the Health and Safety at Work Act or the other relevant health and safety legislation. Where key worker status might become relevant is in the proportionality test under section 100 and 100 subsection 2. However, even there, I think its status is going to be limited because the proportionality is in respect of the steps which the employee proposed to take, rather than in relation to the totality of their position. The summary of the position is that if an employee is in circumstances of danger, an employer should do everything, or if an employer believes that there are circumstances of danger and the employee also believes that the employer should do everything they can to put in place appropriate health and safety mechanisms, that being PPE, social distancing, effective deep cleaning, contact tracing as appropriate. I think there is an inevitability at first instance with a tribunal that a tribunal might afford more sympathy to, for example, a care home expecting employees to attend than to a solicitor's firm. And we all know that there are judges and tribunals which can apply the law more generously than others. But I don't think that any employer should be relying on the work that their employee does to be defending in respect of a breach of what are really quite clear legal obligations.
Beth, just to follow up on that, there was also a question about whether a risk assessment has to be communicated to an employee to make it effective.
I don't know if it has to be communicated to an employee to make it effective as a risk assessment. A risk assessment may, in certain circumstances, be effective for other purposes. However, for the purposes of an unfair dismissal claim, under section 101 D or E, that risk assessment has to be, the substance of that risk assessment has to be communicated to the employee, because if the substance of that risk assessment is not communicated to the employee is much more likely to have a reasonable belief in the seriousness and imminence of the danger, and the employer cannot say that the employee's belief is not reasonable because of the safety measures which the employer was taking. So for those purposes, I would say that it has to be communicated. Whether it has to be communicated line by line or in a manner which enables an employee to understand it and take effective action really depends on the circumstances of the individual and the nature of their employment.
Preetika, I think there's a question for you. Can an employee who's furloughed be asked to line manage other furloughed employees?
So that's also very clear. The requirement to cease work applies to all individuals. That means that if someone is line managing another employee and the line manager is furloughed, then they cannot carry out any of their line management duties. This includes even providing support or checking up on the person they line manage, so nothing at all.
Margherita, another question about redundancy for you. How far do you think tribunals will explore if it occurs whilst a furlough scheme is in operation?
Sorry, could you just repeat that, because my connection just faltered.
Of course. How far do you think tribunals will explore the commercial rationale behind an employer making a decision to implement redundancies if it occurs whilst the furlough scheme is in operation?
Well, so the important point is that there is never an obligation on the employer to show a business case. So in the Polyfloor case, which was cited in the slides, the employment tribunal had held that a dismissal was unfair because there was evidence that the employer, on the employer's evidence, it didn't show that there was an economic need to cut costs and make the employee redundant. The Employment Appeals Tribunal overturned that decision and held that it was clear on the facts that the employee's role had disappeared, and the employer need not show a business case for dismissal. So that's the important point about how redundancy is defined. All that has to be shown for a redundancy situation to exist is that there's been a diminishing need, or a diminished need for the specific employee to perform particular work. So where that exists, where that happens on the facts, it's irrelevant that the employer's business was just as profitable and that there was no sort of cost-related reason for cutting that employee's role. So even in the COVID scenario, where an employee's role has simply become useless, it's dropped out of the picture, then an employer will be entitled to put that employee up for redundancy, irrespective of the fact that it doesn't need to cut costs because the business is growing, for instance. The Employment Tribunal will simply not inquire as to those economic justifications for redundancy, so long as a redundancy situation exists.
Beth, a question for you. Where do you think the threshold will be for a tribunal to be satisfied that an employee faces a serious risk of harm?
I think that's a really difficult question to answer right now, and I expect that this is going to be argued at EAT level and beyond. It's important to note that the employee doesn't have to face a serious risk of harm. An employee has to face a danger which he reasonably gives rise to a serious and imminent risk, and that distinction could be important. I do, however, think that the Employment Tribunal and in time the appellate courts will accept that there do have to be objective circumstances of danger. I think that test is going to have to be expanded. And I think based on the comparison between section 101C and section 101D and E, the tribunal are going to say that circumstances of danger require something more than a potential health and safety harm. I think they are going to. I think they're going to suggest that that separate wording exists because there is a degree of seriousness as to the situation, and that degree of seriousness can materialize in the context of that workplace and that employee. I'm not expecting that they will say that the employee has to be someone who is at, say, an 8% risk of death from COVID compared to a 1% risk of death from COVID. But I do not think that employees are going to be able to rely on the general fact of COVID to avoid attending workplaces which they can attend without using public transport and which do not require very close working with other people.
Preetika, looks like there's another question for you. Is there a legal definition to who is at risk or vulnerable in relation to underlying conditions?
So I haven't seen one included in either the Treasury direction or the guidance, and that's not something that either the Treasury direction or the guidance deals with. So nothing on that front, but maybe if you're aware of any other definitions that might be relevant.
I think there's a follow-up question in relation to guidance as well. Has any guidance been issued regarding those who are furloughed but have been asked to shield long-term, or will there be any other provision? And will their employment be required to remain available pending their return? I suppose that's a broader question about whether there's any job security if employees are furloughed.
So in relation to the shielding aspect, that's something that I did touch upon, and the position there has changed in the guidance. This is set out most clearly in the guidance for employees. So now the requirement, if you're shielding, you're eligible for furlough if you can't work from home, and where the situation where the alternative would be a redundancy situation. So that now seems to be the current position. In terms of job security, I don't think there's anything either in the Treasury direction or the guidance which deals with that and which provides for security in relation to people who are shielding in that sense. It seems to be given, the employers seem to be given quite a lot of discretion in relation to this whole area.
Yeah, and just just building on what Preetika's said, obviously the purpose of the furlough scheme was to prevent, insofar as possible, mass redundancies. So in terms of the purpose of the scheme, it's clearly to maintain and protect employment insofar as possible. And so whilst there's obviously an underlying principle behind the scheme that an individual will be employed while they're furloughed, clearly the scheme has to end at some point, and So it may be employers will need to take steps to commence consultation before the scheme ends, and will begin to consult individually, indeed, with employees who may be surplus to requirements going forward. But it's going to be an interesting time for all of us, I guess, and we'll have to see what transpires, particularly in relation to the extension of the furlough scheme. Another question that's just come up, Margherita, I think might be for you. Will the furlough period be considered part of employment pertaining to 2 years redundancy employment? So I'm guessing that's a question in relation to continuity of employment for 2 years before a redundancy payment is due.
I'm not sure about that. Preetika might have a better knowledge about whether a furlough does count as continuous employment, but I can definitely look into that.
So yes, the furlough period doesn't break the continuity of employment, and so yeah, that is the position on that.
Excellent. And Beth, I think this final question to you, subject to anyone else asking anything. If an employee is requested to go into work but has to use public transport, referencing again Boris's confusing messages, and refuses, can they be dismissed?
The short answer is I don't think they necessarily can be lawfully dismissed. Circumstances of danger, if those circumstances can be proven, do not have to emanate from the workplace. And I think, although I suggested before that it might be difficult for an employee to prove that those circumstances necessarily pertain to a particular workplace, for example, the likelihood of anyone in that workplace having COVID at the relevant point in time. Those of us who use the tube or a bus on a regular basis know quite how filthy they can be and quite how easy it is to pick up a cold or a flu or any type of bug from them. I would suggest that most forms of public transport do present a risk of COVID objectively. Whether the employee can reasonably believe that to be serious and imminent and cannot take steps to avert it would depend on the facts. If, for example, the employee could wear a mask, could wear gloves, and could sanitize their hands, then for a young person with no health conditions, it might be difficult for them to succeed at a tribunal. But alternatively, if they would be required to take public transport for, say, 45 minutes to an hour to get to their place of work, and they said, I simply cannot rely on not touching my face for that sort of amount of time, I would be in such close proximity to other people that wearing a mask would not be sufficient, and hand sanitizer also would not be sufficient. I think in those circumstances, that would be much more likely.
Final question, looks like it's just snuck in before we close proceedings. The question is this: is it better for staff to commence consultation pertaining to redundancy now and keep them on the government furlough scheme in order for them not to complete their 2 years period? I think what the question being asked is there some way to commence consultation for redundancy before staff reach the 2 years continuity of service required to bring either an unfair dismissal claim or a redundancy payment claim?
Well, if employees are put on furlough, and as Preetika noted earlier, that amounts to is essentially considered to be continuing employment, then there's no reason why redundancy cannot be contemplated. So consultation for any redundancies directed at employees in furlough could take place in advance, and it is probably advisable to do so beforehand. The 2 years period is just what entitles an employee to redundancy payment under the statute. So it doesn't, it has to do with whether an employee can claim that payment. So I'm not sure whether it's relevant to just general consultation provisions when employees are selected for redundancy.
Well, thank you all for attending our webinar. We hope you found it informative and interesting. If you have any further questions you'd like to ask any of our speakers, or indeed want any further information about the work our employment team do feel free to get in touch with any of us, or indeed our very, very helpful clerks, Callum and Sam, and we will respond as soon as we can. From all of us at Doughty Street, we hope you're all keeping well and safe, and we all look forward to seeing as many of you as possible as we can in person when it's possible to do so. Keep safe and goodbye.
Bye.